Welcome, everybody. I'm really excited. This is part of a series about tax planning in 2023, an elder law perspective. And today we're really going to focus on what's in your closet. We're going to talk about trusts and taxes. And for me, when we talk about these things, I like to think about a closet. We think about a trust being very similar to that. How can we get stuff in and out of the closet? Who's allowed in the closet. So we're going to talk a little bit about taxation, and then we're going to talk about trust and how that all kind of works together. Now, our focus today is on elder law. And so we often will use certain types of trusts that are really a hybrid between revocable and irrevocable types of trusts that are different than what a lot of people are used to, which is more federal estate tax planning trust. So some of what we might be talking about might be new to you. Don't hesitate to put any questions in the chat, and I'm happy to answer those at the end. So today we're going to talk about trust. And when we think about a trust, we want to think about what does it really mean? And this during tax season, as an attorney, I often get phone calls from accountants saying they're not sure what type of trust this is. And part of today is just kind of thinking about what are the important things to make those decisions. So a trust is really just a set of rules, it's a written set of instructions where a grantor, people also call that a donor, transfers assets to another person, the trustee of the trust, and then the trustee manages that and controls the assets for somebody else, the beneficiary, under the terms of the trust agreement. So it's just a written set of rules whereby somebody transfers their asset to this, subject to this written set of rules. The trustee makes those decisions, and we always have to worry about the beneficiary. So when I like to think about this, I think about what type of trust I'm using. I think about a closet. And the question is, can I get in the closet? Can I get in the trust? So if I'm the donor and I give my stuff, can I get in there? Can I open the door? Do I have any access? And that's really important. And we're going to talk later on about the trust, the taxation law, the IRS code. And it's really important in there whether I, as the donor, can get access to that. We have certain types of trusts, and typically we have a revocable or revocable trust, an irrevocable or irrevocable trust. And a lot of times people will just immediately say, well, if it's revocable, it's grantor, and it's irrevocable, it's non-grantor. And if you learn anything today, what I hope you learn is that not all irrevocable trusts are non-grantor trusts. The fact that it is irrevocable does not mean that we have to jump right into that it's a non-grantor trust. When we talk about these types of trusts, a grantor trust means really, from the perspective of the IRS, that the grantor or the donor retains so much power that we're still going to see them as the owner of it legally for IRS taxation purposes. A non-grantor trust means it's a separate entity, and we're going to have to get an EIN number, and we're going to have to report the tax separately. So we're going to talk a lot more about that, but I just want you to conceptually understand where we're at with this. So again, whether or not we can open the door or if there's a lock on it doesn't absolutely mean whether or not it's grantor or non-grantor. We can't just rush to that shorthand. We think about irrevocable trusts. A lot of times people put out a lot of words, and I just wanted to spend some time talking about those words so we understand that they're all just types of irrevocable or irrevocable trusts. So inter vivos, a lot of times people think, well, if it's inter vivos, that it can't be irrevocable, or it absolutely is. I have people say both things. Inter vivos just means I made it during my life. That's what it means. It's a trust made during my life. So it could be revocable or irrevocable. A trust under will, again, the same thing, where a trust under a will, obviously I can change my will, so I could change that trust. But both of these types of trusts, once somebody dies, they do become irrevocable. And that happens automatically. So if you were looking to do a tax return for a trust after somebody passes away, that by definition becomes irrevocable. And that's often a place that we are getting EIN, and it is a non-grantor trust. And so important to think about that. Life insurance trusts, most every life insurance trust is a non-grantor trust. And that's because that's a type of trust that I alluded to earlier that really is designed to avoid federal estate taxes. And that is not only irrevocable, it's also a completed gift trust. And so that's important. We're going to talk about a completed gift too, moving forward. Charitable trusts, like a CLAT or a CRAT, beyond the scope of what we're going to talk about today, but I just want to kind of point out to people that these are all types of irrevocable trusts. I also want to, we're going to spend a little bit of time on this, talk about the fact that it can be a completed gift for federal estate tax purposes, but still be a non-grantor trust. And again, this is something, we're talking about this today because it's something that I see all the time where people say, well, if it's a completed gift, it has to be this, or if it's not a completed gift, it doesn't have to be that. And unfortunately, the IRS tax code didn't make it that easy for us. It would have been nice if it was just like cut and dry, but both of them use different words, and we're actually going to look at the statutes and the regulations, and we'll look at some of those words. For federal gift and estate tax, again, which is often what people are a little bit more familiar with, which always makes me wonder. I think the reason, today the exclusion's $12 million, and if I'm under that, I don't have to pay. It's actually $12,090,000. Goes up a little bit every year. If I'm under that, I don't have to pay federal estate tax. But when I started my career, that exclusion was only $600,000. And so a lot of practitioners have a lot of experience with federal estate tax because it was so prevalent in the 1990s, early on, where today it's not as much, but we can't take that body of knowledge that we have and just apply it on other types of trusts. But just to know, federal gift and estate tax, the burden is on the donor, the giver. The tax is on the donor's right to transfer the assets during their life or upon death. So always important for us to know. As I said, for 2023, it's $12,090,000 with a 20% tax break. In 2025, it's supposed to sunset back, but it's inflation indexed to what it's sunsetting back to. So we don't know exactly what that's going to be. But I read a lot and I see estimates of 6.2 to 6.8. Actually, I just read something last night that had that estimate a little bit higher. And I think that's because of inflation that's happening right now. The 2023 annual exclusion of $17,000. This is the amount of money that we can give without using any of the coupon, any of the $12 million to our beneficiaries. And so often clients or practitioners that just do this a little bit will say, can't you give away $10,000 every year to people? And the answer to that is yes, you can. That's what the rule was for many years. And now it's inflation index and it goes up. It used to go up about $1,000 every couple of years. And now the last couple of years, it's went up $1,000 every year. So that is the amount of money that we can give away tax-free. Now, I just want to pause and slow down because I know that I'm interacting with you with some federal estate tax and nursing home. And the idea is that they're a little bit different. So again, my average client will talk to me about, can't I give away $17,000? They'll actually say 10,000, but they mean the 17. And that is an exclusion from using up any of your exclusion for the federal estate tax. But it doesn't have to do anything with nursing home care. So honestly, for most of our clients, most of my clients don't have $12 million. So they really don't have to worry about this very much. And even if it were to sunset back. Now, the reason this is important, and we still have to talk about it, is there's always pending legislation to reduce that even more. So when we look at the newest budget proposal from President Biden, certainly federal estate tax is something that's being looked at to get rid of tools that we use or bring down this exclusion. We also want to talk about Pennsylvania inheritance tax because, again, when we talk about irrevocable trust or revocable or grantor versus non-grantor, people will make an assumption. If it's revocable, it's taxable. If it's irrevocable, it's not taxable. And that's not at all what the tax code says. Difference here, Pennsylvania inheritance tax, the burden is on the donee, the person that receives it. They have to pay the tax. And the tax is on the donee's right to receive the assets upon death. So what that means is, and we talked about this for federal tax, it's a little bit different for Pennsylvania, but what that means is that you don't have to like give everything. You can put something into a trust, and if upon your death, somebody has the right to receive that, that makes it inheritance taxable. And this is really important because a lot of people say, if I put my stuff in an irrevocable trust, I'm not going to have to pay federal estate tax or Pennsylvania inheritance tax. And that's not always true. We really need to look at, does the person have the right to receive anything upon your death? Important for Pennsylvania inheritance tax, Pennsylvania does tax $1. And then it's a percentage based on who's receiving it. So 0% to spouses. When I first started my career, there was a tax between spouses, and that was one of the most unpopular laws ever. Early in my career, I used to have to tell people, yeah, your husband died and now you have to pay tax to inherit the money. But that has been gone since about 1993 in Pennsylvania. 4.5% on direct descendants and lineal heirs, 12% to siblings, and 15% to other people. Like I always say to my clients, the mailman, or what comes up more often is the niece or nephew that is taxed at 15%. So that's why understanding this is so important, because we don't want people just employing certain types of trusts and assuming some taxation, either income or taxation upon death. It's something we really need to look at. And unfortunately, the answer is we have to look at each trust individually. So just to give you an example, what would be a grantor trust? That's a type of trust that at the grantor's death, all net income of the trust estate shall be paid to the grantor's spouse in convenience installments, at least quarterly until the grantor's spouse's death. It also could be, the grantor puts money in and says they retain the right to income their whole lives. That's something that you'll see. You'll see this type often, especially in second marriages. And you'll hear people talk about RLTs, which are revocable living trusts, or Q-tips trust, which is a qualified terminal interest. So in that situation, we want to think about that. So this chart shows an example of a revocable living trust, and you'll see at the top the trustees are the grantors. So let's say it's me and my husband, and we're the grantors. We put our money in here. We are the trustees. We're also totally the beneficiaries. And what happens upon, and we have access to all principal and income. What happens upon during our life is that this is a grantor trust. So for income tax purposes, it's on my tax return. Now there are different ways to report it. And certainly some people will get an EIN, but we really want to understand we have this favorable tax treatment as a grantor trust. Doesn't change a lot. Also at my death, this is going to be subject to federal estate tax, and it's going to be subject to Pennsylvania inheritance tax. Now, the other parts of this are kind of beyond the conversation today, but this is a type of trust that's often used, a Clayton tax election trust, where basically Mrs. Clayton sued the IRS and said that she should have the ability to decide which of these trusts everything goes into upon her husband's death. And really, this is a response to all the changing laws and what people used to call AB trusts or marital trusts, and these fractional shares that had to have happen. And so today, a lot of times we'll use this Clayton election. And again, if it was my husband and I, and let's say I passed away, my husband would decide how much of it goes into the surviving spouse trust, or that Q-tip trust that I talked about, or the family trust, which would avoid federal taxation. So moving forward, there's a lot going on in this, but beyond the scope of the conversation today. So I just want to really kind of talk to people about why is it that we should be using a grantor trust. We really, most times, are not using it for federal estate tax planning for the person that we're setting it up for. We do use it, like this type of trust that I was showing you, we would use that for great spousal planning. Now, there's other ways to do that, but there's a great way to have it like a second marriage. Again, my husband and I pass away, he receives it, he gets part of it that he can get income off of it, and we use some of my exclusion. We still save his exclusion. So we have $24 million between us, which is the $12,090 times 2. Provided the grantor spouse, great credit protection for our beneficiaries, not for the people doing it, but for our beneficiaries. And for some people, we are doing it for income tax planning. Now, a non-grantor trust, which is the other type of trust in the tax code, just an example of that, the trustee pays beneficiaries the net income or principal of the trust as the trustee deems advisable by a HEM standard. So for instance, and HEM stands for Health, Education, Maintenance, and Support. So you'll see, again, these types of trusts used often for the grantor spouse and dependent. Difference here is a non-grantor trust. In this situation, the grantor doesn't retain the same rights that the other trust does. So why would we do that? Again, some creditor protection. Divorcing spouses of children is a great reason to do that. This is sometimes a non-grantor trust is used for federal estate tax planning, sometimes for income planning and Pennsylvania inheritance tax planning. So it says a grantor trust allows assets to grow tax-free, much like a Roth IRA. True or false? Yes. So absolutely. Now, I didn't exactly talk about that, but again, the idea from it is, what I did talk about is that the tax is still paid by the grantor. And so that's really important. Honestly, in Pennsylvania, there was a lot of scams where people would tell people, here, put your money in the trust and you don't have to pay income tax. Now, some of those attorneys were disbarred for doing that, but unfortunately, some people still believe that. The question really with this grantor trust is, for the grantor, is the grantor paying the tax, or for the non-grantor, is the trust paying the tax? Although we can also push that down to beneficiaries. But for today, it's just whether or not, who's ending up paying that tax. And I think just to sum up, the grantor, if the grantor retains certain powers, the grantor is going to pay and is being considered a grantor trust. Now, up to now in our conversation, most of those powers that I've talked about is retaining income. Because that's what we see the most. We see people retaining income. But definitely there are other examples, and we're going to get into that tax code. So when we think about the grantor trust, we want to think about, that we have access to the closet, that we can move forward. And for a non-grantor trust, somehow, some way, we don't have access. There's something that we haven't retained. So we're going to jump into the code. So it's really 671 to 676 that gives you these powers. And so the idea of it is, if I read the trust document and I have any of these powers, it is a grantor trust. So again, remember in the beginning, I said, if it's irrevocable, doesn't necessarily mean it's a non-grantor trust, that it can't be a grantor trust. Here's where we're really looking at it. So first of all, the power to revoke. Now that is a revocable trust. So that so 676 just says, I'm the grantor. I grant the stuff to this trust, but I retain the power to revoke it. I can amend it. I can revisit it, moving forward. Now, I want to point out for everybody who does do federal estate tax, The 676 of the IRS code is the grantor trust statute, but I always like to then also think about the code sections that deal with federal estate tax. So I have written down there code 2038, which that is the statute that also makes this federal estate taxable. Pretty common knowledge here, if I can revoke it, that it's going to be subject to federal estate taxes. But the 676 is the income tax code, and the 2038 is the federal tax code. So what about other types of codes? So a reversionary interest. So what a reversionary interest means in a trust is that there's some right to revert it back. So that could be, I've seen them in my career where I give my son this land in this trust, but if he ever opens a bar on the land, it reverts back to me and to his siblings. I've actually seen that in a trust. That's a reversionary interest. It means I'm giving it to you, but if you don't play by the rules I set up, it reverts back to me. Sometimes when people donate land, they do it that way through a trust. So where I live, a family donated land to be used for an elementary school. And as long as it was used as an elementary school, and they actually closed that elementary school. And in that document, it said the land reverted back to that family. That's a reversionary interest. That makes this a grantor trust. You don't see them a lot, but they do exist. And again, this would put this, the federal tax code that would say, okay, if I do this type of trust with this reversionary interest, this is also going to be subject to federal estate tax. It's going to be included in my federal estate taxes. And I do want to point out to everybody before you stop listening about the federal estate taxes, and we'll get to this a little bit later, but I want to make sure you're aware. Sometimes I want things to be included in the federal estate tax because right now, if it was included in the federal estate tax, I get a step up in basis. So that's why this is important, because if I get a step up in basis and then the person turns at death. So again, remember, let's say I make this trust, I put this piece of land in here, and it reverts back to me or my family if some condition happens. That's a reversionary interest. Because of that, it's a grantor trust. So for income tax purposes, it's a grantor trust. But also because of 2037, it's going to be included in my federal estate. And I could care about that if I have close to $12 million. I also could care about that if it's something that I want to get a step up in basis on upon death, so that when people turn around and sell it, you don't have to pay as many capital gains tax. And we'll talk more about that. But I just wanted to point that out right now because I don't want people to think that it's not important moving forward. The power of disposition, and so that's the power to get rid of something. So that's the power of who's the beneficiary. Can I change? I say in the trust, upon my death, this goes to my kids, but I have the power to change it to somebody else. I could get remarried and give it to my new spouse. That's the power of disposition, the power to change beneficiaries. The only exceptions to that is if they're governed by a reasonable standard, such as the HEM standard. And I talked about that: health, education, maintenance, and support. So a lot going on here with the power of disposition, but generally, if I have the power to say who gets it or how they get it, it's still a grantor trust under 674. And so we know that that's the way it is. Power to add beneficiaries. That's not an adverse party. So a non-adverse party. So I could add beneficiaries such as I always joke that my mom loves her grandchildren more than her kids. My brother and I are okay with that, but my mom recently did that. My brother and I were the beneficiaries, and she recently came and added her grandchildren, like as equal people. So that again, under 674, if a trust gives the grantor the power to do that, then you're going to see this moving forward. So And again, 2036 is the federal part that's string. We call it a string because it pulls it back into the federal estate. And so 2036 is actually, from my perspective, it's probably my favorite tax code. I probably say it more than anything else. 2036 allows stuff to be pulled back into the federal estate. And at my office, a lot of my clients don't have $12 million, but we want the step up in basis. So we're actually creating trusts that would be included in their federal estate because we want this string to pull it back into the federal estate so we get a step up in basis. So important moving forward. And this could be a type of trust at our office that we use that protects against the cost of long-term care. So this grantor power, I often use in a situation where I have an irrevocable trust. So every other part of it is irrevocable. Yet because of this, it's a grantor trust and can be written in a way that protects assets from the cost of long-term care. So really important. So the power to add the beneficiaries, who should hold the power? Well, if the grantor holds the power to add those beneficiaries, it's considered an incomplete gift, and assets are included in the federal estate. If it's a beneficiary, so if I say I don't get to add beneficiaries, but I'll let my children add beneficiaries, the beneficiaries themselves, it could be considered grantor to them. And so we want to think about that. Income, more grantor rules. Remember, it's 671 to 677. The income for the benefit of the grantor. We see these all the time. I put my stuff in a trust, but I retain the right to get income. I put my stuff in the trust. Upon my death, it goes to my spouse. They retain the power for income. Or the power to use income to pay life insurance premiums is another one that we see a lot with federal estate tax planning. So important for us to be thinking about these safe powers. These are powers that I can put in a trust. It makes it a grantor trust and is not included for federal estate tax purposes. So these, when I have a slide about this, but these are often called intentionally defective grantor trusts. So these are the Superman of trusts, if you will. They really put the line between the two purposes. So if I want again, let's say I'm setting up a trust, I'm the grantor, and I want grantor status. So I want to pay income tax based on it being a grantor trust for me. I could have an irrevocable trust that is not included in my federal estate. And the way that I do that is I add the power to add charitable beneficiaries, the power to make loans to myself without adequate security, the power to substitute assets of equivalent value, and the power to use income to pay premiums on life insurance policies. So these are the powers that are in the grantor trust rules that I would choose in a situation where I want a grantor trust for income tax purposes, and I don't want it included in somebody's federal estate. So that's a fine line, but these are really exciting trusts because we can do a really neat thing here with these powers. Now, for some people that are listening, you may not have known anything about these grantor trust rules. And at one level, I really just want you to understand that they exist, and that if you're doing taxes, you need to be deciding whether or not it's a grantor or non-grantor trust. And any of these things that I talked about, if the grantor retains those powers, it is a grantor trust. The next level of it is, well, based on what else the document says, is it included for federal estate tax purposes? Now, we're today not getting into making that determination of whether or not it's included for federal estate tax purposes, but just know that these types of powers, if people are using them, often it means that they don't want it included in federal estate tax purposes, and the ones I mentioned before would be included for federal estate tax purposes. So I mentioned an IDGIT, an intentionally defective grantor trust, which we use often in this situation. It is an irrevocable trust. It is a completed gift for federal estate tax purposes. There's no federal estate tax inclusion, and the grantor has to retain certain powers. Now, understand the grantor is not retaining all these powers. They're the powers I just went over in the last slide. They would be retaining one of these powers, typically one of these powers. And there's reasons why we use one power versus another. In Pennsylvania, we don't use the power to add charitable beneficiaries if we're dealing with real estate because it's going to make it realty transfer taxable. We're also probably not going to use the power to substitute assets if we're worried about Medicaid. So there's lots of reasons why we use these important things. But again, part of what today I really want to talk about is just this important question: is the trust grantor or non-grantor for income tax purposes? And what I hope you got out of what we talked about so far is that it doesn't matter if it's an irrevocable trust. That's only one part of 671 to 677. Income or principal only, the status applies only to income and principal. If there's a fractional or some sort of part of the share in the trust, the power to borrow up half the assets. So you want to think about, has it been a grantor or non-grantor? Has there been a completed gift? Does the grantor still have any power consideration, or do we have adequate consideration? So this type of trust offers the power to revoke or the power to add beneficiaries. So if a trust had the power to revoke or the power to add beneficiaries, would you consider that a grantor or non-grantor trust? So that would be a grantor trust. And they're really what I would consider the most prevalent types of grantor trusts moving forward. So we know a little bit now about a grantor trust. And I want to add on that knowledge. We talked a little bit about an intentionally defective grantor trust. And I want to add a little bit about that knowledge about whether or not a gift is complete. So again, let's just think about, let's say I set up a trust. I'm the grantor. We put it in the trust. We know it's a grantor trust because I've retained certain powers. Now I want to decide, was that gift completed? Should we be doing a gift tax return on that? Or is it not completed and it's going to be included in the federal estate? So again, often people think, oh, if it's a grantor trust, it's not a completed gift. That's not true because we have to look at the regulations about that. And so this is actually the Treasury regulation. And it talks about a gift is also incomplete if and to the extent that the reserved powers give the donor the power to name new beneficiaries or change the interests of the beneficiaries as between themselves, unless the power is a fiduciary power limited by a fixed or ascertainable standard. So we see this all the time in nursing home trusts that we use. So when I talk about Medicaid or nursing home, I'm talking about a type of trust where somebody comes to me and maybe they want to protect their home from the cost of long-term care. They put their home into a trust. After 5 years, they would be able to get Medicaid. Now, depending on where we live in the nation, how beneficial that is to them, but people are still, protecting farms and cabins and all kinds of things because the cost of long-term care is $12,000 a month. So it's an important thing. So in these types of trusts, often they're irrevocable. They are often grantor trusts because we want them to be grantor trusts. And they're incomplete gifts because we often in those situations would reserve powers to the donor, the person putting it in there, to name new beneficiaries or change the interests of the beneficiaries. So what does that mean? Could mean that, like in my situation, I have 3 kids. I take my house, I put it into a trust, but I retain the right to decide I'm going to give it equally to all 3 kids. I'm going to give it to one kid versus all 3, because maybe I give the other ones something else, or maybe life just works out that I don't think they should have it. Maybe I'm going to give it to my grandchildren, or maybe I'm going to give it to a new spouse, but I retain that power. So that type of trust, which is often used, you will usually see that be a grantor trust and an incomplete gift. And then what happens upon my death is we get a step up in basis. And so if I did that and I gave it to my 3 kids and they sold it after my death, then what would happen is they wouldn't have to pay income tax on that sale. So it's actually a really neat type of a trust to be using, particularly with people who don't have $12,090. Maybe they come, they have a house and $1 million, and they're worried about what happens if they get sick, and they want to avoid probate. So really neat types of trust. And so we wanted to know what to do with them. So I have in here just an example. This is an example of actual wording used in a trust. And, typically in a situation like this, if you're not able to see that screen as well, it is something that we would provide handouts for you. But the trust created by this agreement shall be, this is actually what the trust document says. The trust created by this agreement shall be irrevocable. The donor may not revoke or amend this agreement. However, each donor without the consent of the other, so like husband and wife often would be why we'd have two donors, retains the power to change paragraph 2.1, which talks about distributions of trust, principal, and income. And 3.1, disposition upon termination of the trust agreement to remove any beneficiary. Additionally, each donor without the consent of the other retains the power to change paragraphs 2.1 and 3.1, or to add any of the donor's issue or the spouse to any of the donor's issue or a trust for the benefit. So again, giving you those really important things for you to see. This is actual wording that you would see. And if I came across this wording, what I would know then is that this type of trust is, although irrevocable, is a grantor trust, and it's an incomplete gift, all by that paragraph. And please know, I think that whoever creates the trust, if an attorney creates a trust, they should be providing this information to you. But I also think that you should be able to verify that information. Because if you're the one filling out the tax return, we would want to have that verified moving forward. So now, so far in this presentation, I've talked about grantor versus non-grantor as if every trust is one or the other. And now I'm going to add to that knowledge that a trust can be grantor as to principal and non-grantor as to income. Like it can be either. And so a good example of this is putting a rental property in a trust. We might be non-grantor as to the real estate itself and grantor as to that income. And sometimes we want that to happen because if the income, the rent is coming in, we want that going back on the grantor's tax return and that they receive that income. But there's some benefits out there like veterans benefits that we need a non-grantor trust. So that's why we'll do something like this. So just want to point out to people, I know up until now I've talked about it as if the whole trust is one or the other, but really a trust can be grantor as to principal or non-grantor as to principal, and income can be different, and we often do that. So this is an example of that. Paragraph 3.1.3 of a trust document says this shall be irrevocable. So we have an irrevocable trust. We know that the donor cannot revoke or amend it. However, each donor without the consent of the other, and again, that's often husband and wife. We want to make sure that if one of them passes away, the other one can continue making changes, retains the power to change paragraph 2.2, which talks about trust principal. So again, in my situation, my scenario, who gets the rental property, like who gets the actual piece of real estate when somebody dies. But the donor does not retain the power to change 2.1 distributions of income. So we can't change who gets the rent. And so we don't often use these types of trusts. They're a little bit more complex, but there are certain benefits that we would, again, veterans benefits is an important part of that. We want to also be talking about when the grantor only owns the income portion, then only tax on ordinary income items. The trust is taxed on capital gains. So an example of that is if I sold the rental property, that would create a capital gain, and the trust is going to pay the tax themselves unless we distribute that out to a beneficiary. So now please know, in a trust document, the the document itself can define income differently than this. But most times income is defined as dividends, rents, what we would think of as ordinary income. And that income portion would go back to that grantor, but capital gains goes with the principal, and usually not included in the income definition of a trust. So we would have to check the definition. If the trust is silent, that is the default in the law. So if the trust doesn't say, but most trusts do say near the back of the trust, it'll have a definition of what is income. It should have a definition. If it doesn't, capital gains are not included. But often in that situation, that's sometime that I would want to sit down with my clients and say, what did we intend? Because it's not really defined in here. We also can have it to be a grantor trust for just a specific asset. So here's an example of a grantor trust position just for a specific asset. And so we see here, this is again, actual language in a trust. We intend that we be taxed as owners of this trust for federal income tax purposes for the periods during which either of us or any other person holds one or more of the powers described in 671 to 678 of the Internal Revenue Code. All provisions of the trust will be construed to carry out this intent. Notwithstanding any provision of the trust that may seem to be the contrary of the trust, the following provision shall apply. And in this situation, we're using the power of substitution. During our lifetime, each of us reserves the independent right to reacquire any trust property, excluding life insurance. So by substituting equal. So what happens is this is a grantor trust as to every asset in there, but life insurance. And now it's a non-grantor as to life insurance. So again, these are some complexities that aren't used as often, but I wanted to let you know that they can occur. It's something to be looking out for. So we can have grantor versus non-grantor as to income and principal. We can have grantor versus non-grantor as to specific assets, moving forward for us to be thinking about. So next we're going to talk about a grantor trust and a completed gift. And we have an example of that. Here we have a situation in this where it is a grantor trust. So that means I retained that power of substitution. That makes it a grantor trust. But remember that this is a completed gift. And this allows this right here would be a type of trust that would be grantor, but a completed gift. So that power of substitution moving forward. Non-grantor and completed gift. Here we have a situation where, again, all of these, they're irrevocable trusts, because if they were revocable, they would automatically be a grantor trust. So this is an irrevocable trust. The first paragraph just says, hey, you can't revoke it or amend it in any way. But we are allowing some administrative provisions with the management administration. And in no event shall any amendment affect, enlarge, or shift any beneficial interest created there under moving forward. Our next topic we really want to talk about is, and I've alluded to this, but really kind of talking about basis. So all of this is really important, whether we're doing income tax preparation for the trust itself, or if we're advising people or doing tax preparation moving forward based on assets that are sold within the trust. So trustation and taxes, we're going to talk about gift tax, and we're also going to talk about some basis issues. This is where I can get really excited about what the tax law allows us to do, because we are pretty easily able to get something included in a federal estate. Now, the reason we're able to get something included in a federal estate is because the laws are written to get inclusion so that people were, so the IRS was able to collect tax dollars, right? But in our situation, if we have a client who does not have a federal estate or anywhere close to the $12,090,090, we often want that inclusion and we want to get a step up in basis. So just to kind of talk about it, if I have a non-grantor trust, remember I haven't retained any of those powers. That means I'm getting an EIN number with this non-grantor trust. The grantor really doesn't have any real powers over it. And the next thing I want to look at is see, is it a completed gift? Now, typically it's going to be a completed gift. And in that situation, the donor's basis transfers to the donee. So if I talk about my situation, remember I talked about putting a rental property, a piece of real estate property. That means that when I put that piece of real estate property into that trust, that's going to carry over. Now, this is subject to all the carryover loss rules, everything, but just generally a carryover basis. So if it was worth if I had a basis of $100,000 when I put it in the trust, I also have a basis of $100,000. So in this situation, the example we have here is the real estate's purchased by the grantor for $10,000. That's their cost basis in the property. And the grantor gives it to a trust for his children, and the trustee decides to sell it the day after the grantor dies. In that situation, I have a $100,000 fair market value of death. I have a $10,000 carryover basis. And so then I'm going to be taxed on the capital gain of $90,000. So that's a non-grantor trust where I have carryover basis and no stepped up basis at death because it's a completed gift. What if, though, I did the same thing, but in this trust, this situation, I had a grantor trust. Well, it wasn't a completed gift. Same situation. Real estate's purchased by the grantor for $10,000. It's put into a grantor trust. That's an incomplete gift. It's given to his children. His children, he passes away, and they sell it. There's no capital gains because we got to step up in basis at death. That's why this is really important. So sometimes in my practice, people will say, I'm going to give my house to my kid for $1. Well, that's not always a great thing because if I give my house, just put their names on it and I pass away, I'm not getting the step up in basis, right? If I use a type of trust whereby I'm going to get a step up in basis, what ends up going to my children ends up being more. Now, I put down at the bottom of that slide, Pennsylvania inheritance tax is going to be paid at 4.5%. And so that's not true in all states. Pennsylvania is only one of 11 states that has an inheritance tax. It's the only state that it taxes $1. But you have to watch that. But in my state, a lot of times people will say, well, we don't want to pay the inheritance tax. Well, you can avoid that 4.5%. And you're going to end up paying more capital gains if you sell it. That's why this is so important, particularly on property that's been held a long time. All righty. So I've come to the point in time where if anybody has any questions, I'd be happy to take those questions. Otherwise, I just thank you for your time.